It's the weekend, and that means while your lawyer is mowing his lawn, I'm reading every Illinois appellate decision and reporting back to you guys the cases that I think are interesting and form the basis of recent developments in Illinois family law. This week's case is in regarding the marriage of Kehoe and Garavaglia. James Kehoe marries Lilia Garavaglia in Italy in the year 2000, and while they're getting married, they have to fill out a bunch of forms for the Italian government. One of those forms requires them to pick a property regime. There's two regimes. Regime one is community of assets, which says all the property they acquire will be considered marital in the future and divisible. And property regime two is separation of assets, which says that all the property they acquire in the future will be considered their own separate properties. Well, they pick number two, they fill out the form, they send it in, and then they get married, and then they live everywhere but Italy for 20 years, New York, Connecticut, Chicago, and finally they file for divorce in Cook County, Illinois. James rushes into Judge Goldfarb's chambers and says, look, I filled out this atto de matrimonio that says I picked a separation of assets, so all my stuff should remain my stuff. Judge Goldfarb says, well, wait a minute, maybe, but let's see if it really is a contract. So Judge Goldfarb takes the testimony of both parties and finds out that they really just filled it out as a form. They didn't think it was enforceable, and they didn't think it was enforceable outside of Italy, which they never planned on living in. So Judge Goldfarb says, sorry, there's no meeting of the minds, so therefore it's not a contract. It doesn't govern or control anything in the Illinois Marriage and Dissolution of Marriage Act. So the case will proceed where all the property is marital, just like the law says here. So sorry, James, your atto de matrimonio will not work here in Cook County, Illinois.